Good morning. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA23-011, People of Guam Plaintiff Appellee versus Phillips James Sablan, Defendant Appellant. Appearing for Defendant Appellant is Attorney David Highsmith. Appearing for Plaintiff Appellee is Attorney Christine Tenorio. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Highsmith reserves 15 minutes.
You may proceed, Mr. Highsmith.
Morning, Your Honor. May it please the court. The court is familiar with this case. It has been up on appeal before, but we want to emphasize that this appeal is different. The other appeal was an interlocutory appeal from a decision to grant a new trial, and the standards on this appeal are different, and the court is not bound by the previous decision in this case. The court is free to reconsider such issues as it chooses and may look at what happened in the previous appeal in the trial court.
Can you, I'm sorry, I'm a little congested, so I have to wear a mask here. But can you explain your reasoning behind your argument that the law of the case doctrine does not apply in this case, despite our ruling on the issue of 404B evidence?
Yes. The main ruling of this court on the first appeal was that the court had applied the wrong standard in granting a new trial. And once the court ruled that, the other rulings made by the trial court became of secondary importance. The court held that the trial court had ruled essentially based on the credibility of witnesses. And once the court says that, the other issues are of much less importance. And so
Can we say it wasn't central to the holding of the case? Is it dicta or?
well, I think that the other holdings of the case shade into dicta, yes. Because once the court said that the first appeal, the decision to grant the new trial was wrongly granted on the wrong standard, it almost doesn't matter what the rest of that decision says. If you have more questions on that, Mr. Justice.
Well, I just, and it's the argument that the law of the case doesn't apply to
Yes.
the other reasonings or the other findings of the court if it wasn't central to the holding?
Yes, and that what we end up with is a manifest injustice or clear error, because it seems evident now that Mr. Sablan, by any standard, did not get a fair trial. I'm not sure what more I can add that the court hasn't been briefed to death on.
Well, can you explain why you believe the previous discussion of the court in Sablan 1 on the 404B issue should not be followed in this case?
It is evident that the court applied traditional reasoning on prior acts of sexual abuse and 404B and did not consider certain points about 404B. First of all, there's the decision from a federal court where it was a civil case, and the attorneys for the one party said, well, this is 404B evidence, but we can meet it. And the court relied heavily on that case to overrule the trial court. But if we look at it closely enough, the party opposing the 404B evidence agreed to have it come in. That's not what happened here. And also, I think the notice, so-called notice that was given to the defense was highly defective for the reasons set out in the brief. We don't know what happened, when it happened. It doesn't even say that it was the defendant who touched the young lady. So it's really not convincing. I was shocked. I was shocked when this was brought in.
Can we go back first and let's break it down, just take a step back and look at the notice provision of 404B and then look at what occurred here. 404B says that, you know, they have to provide reasonable notice in advance of the trial or during the trial if the court excused pretrial notice or that there's on good cause shown, but they have to provide the general nature of the evidence and that it intends to introduce at trial. Obviously, what we're focused on here is the report from the Attorney General's investigator that showed that there may have been more than one touching incident other than the one that was alleged in the indictment.
Yes.
The government asserts that they did not intend to use that evidence at trial. That's their assertion is that her testimony was specifically directed and they intended to limit her testimony only to the events that were alleged in the indictment. And that in fact, the stricken testimony, according to the government, the stricken testimony actually does not consist of prior bad acts or prior acts because she was testifying to the act that was charged in the indictment.
Well, if we go back and look at the questions asked by the prosecutor, we will see that that is not true. He said something to the effect, were there any other times when he touched you? In other words, he knew he was talking about other incidents.
Well, I think when you look at the testimony, and it was on the March 31st trial date, when she initially answered, the initial question was, how many times did he touch you there? And she mentioned she was with her auntie, and I think there was some confusion as to whether that incident, which happened when she was maybe 4, was the same incident that was testified to in the later on. But what on redirect, wasn't there some question about clarifying what the incident was with the teacher, Mr. Kanata?
You mean, did the teacher testify?
No. When the prosecutor tried to rehabilitate her testimony.
Yes, well, yes, there was. He brought in testimony about when it might have occurred. It wasn't very convincing, and the prosecutor kept contradicting himself. He kept saying, no, this is only one incident. Then he'd turn around and say, no, it's legitimate 404B evidence. The indictment was very specific. It said April 1st to April the 30th.
Yeah, correct. Both incidents were alleged to have occurred during that time.
No, I don't believe so, Your Honor.
The touching and the
exposure. Well, yes, those two incidents.
Right.
Yes.
Right. They were both alleged to have occurred
Yes.
during that time. Yes.
And I thought going into trial that that's what we were talking about. And the evidence established that it must have happened, if at all, on the night of April the 15th to the 16th. Everybody testified to that, and the prosecutor agreed with it.
So if it wasn't, obviously it can't be so easy for the prosecution to get around and suggest, well, I didn't intend to introduce it at trial and then the testimony just happened. But if it was a situation where a minor witness and they don't intend to question her about any of those other actions, potentially there could have been reasons why they didn't want to prosecute him for those other alleged incidents. But this one incident that was there, so the focus of them was they only wanted her and the evidence that they were going to bring in and introduce at trial just related to that one incident. But then she digressed and brought up some other situations that's there. Should the prosecution be held accountable for that?
Yes, because I don't think that the scenario they suggest is true at all. The prosecutor kept arguing that we have the truism now. Time doesn't matter. She's just confused. Then he turned around and said, "But this is a legitimate prior incident." It put the trial court in a very difficult position to know what we were talking about. And the two incidents that the girl did give some detail on are quite different. One, she was followed into the bedroom and he touched her. The other, she was asleep and he reached down and touched her.
If we take the stricken testimony, and obviously the court struck it, the jury was instructed not to consider it. What is the evidence in the record that exists regarding the touching between April 1st to April 30th? I mean, you have the testimony of the aunts, you have the mother-father testimony, but
yes.
I'm talking about is there any testimony from the child witness, from the minor, that about the touching on that day or in that period?
Well, that's a good question. She talked about two different incidents. One of them, she said, happened on the same day as the exposure incident, but that's nearly impossible. Mr. Sablan admitted there was something like the exposure incident, but that it was an accident. And he said it happened in January. There were only two times that year, 2020, when the family stayed at the Sablan house, January and April. And the testimony was all related to April the 15th or the 16th, but the girl couldn't separate things in her mind. And it's not clear that she ever really talked about April the 15th to 16th. The first time she gave the account of what happened to Mr. Sablan's live-in girlfriend was 2 to 3 weeks after what happened. And she gave an abbreviated story to the police. I don't know that her memory was ever plumbed by a CPS worker and straightened out. The CPS, I believe it was a CPS social worker, was excluded from testifying. But there were texts on the night, on the morning of the 16th, indicating that it had to be April the 15th and the 16th. It couldn't have been any other time. We don't really know whether the girl's testimony related to the month of April or not.
Does it have to?
In this case, I believe it does. Yes, Your Honor, because all the notice said it was April 1st to April 30. We know these notices can be drawn up very broadly. They could say April the 1st, 2018 to 2020. But that's not how this was drawn up. It named a specific month, and we know when that month was, and we know they were there. We know the girl slept in the house, but we don't know what happened. One thing about those texts is they were communicating about who was going to drive home from the house. And if you're sleeping in the same room, why do you need to send texts back and forth like that? I believe there was some evidence that they didn't sleep in the same room that night. But I went into trial thinking about April the 1st to April the 30th, and I had no notice of that prior event. I don't know what more can I say? If it had said starting with age 4, which it could have, I'd have known that we were talking about a longer period of time.
But that's not in and of itself. If there was prior acts, that doesn't necessarily mean that it can't come in under 404B. And so long as it's not used for propensity purposes.
Mhm.
So what was the government's statement in reference to those incidents coming in as prior acts?
Well, once again, it was confusing and contradictory. The prosecutor said, no, this is the same incident, which doesn't seem possible. Not if one happened when she was 4 and the other one happened when she was 8. Not if one happened while she had a certain teacher, Ms. Kanota, I believe. Then he turned around and said, oh, she's just confused. In fact, he argued that the evidence should come in because she was confused. And he kept vacillating on this back and forth. And, there's supposed to be analyses done by the trial court on these materials. Does 404B apply or not? Does 403 apply? The court was in no position to make those analyses. And in fact, the court said 404B applies and it doesn't come in. It never even got to 403. And of course, we all know that 413 was not mentioned. But the government, with this vacillating, nevertheless, never gave a reason that is never named an exception mentioned in 404B that would apply. What did it come in to apply? Motive, intent, opportunity. None of those things were mentioned. None of them seem to apply. Now, the government I didn't argue 413. Perhaps I was not as well prepared as I could have been, but the prosecutor was not prepared either. He did not argue it. Ironically, if 413 had been applied, well, we all know it's broader than 404B. And maybe the court would have made a better informed decision, or maybe we'd be in a different set of circumstances here today. But if 4103 is really the applicable law, then it behooved the prosecutor to so argue.
You went over the 15 minutes that you reserved. I didn't know. You have 12 minutes remaining.
That's fine.
All right.
Thank you, Your Honor.
All right. Thank you, Mr. Highsmith. Mr. Nair.
Mr. Chief Justice, and may it please the court. This is a case where the defendant has circumvented his petition for rehearing to have this court re-examine its opinion in Sablan 1 and tries to resurrect the same issues on appeal, and this is what is now Sablan 2. The government's position is that most of the issues on appeal are barred by the law of the case doctrine.
But weren't there some issues that he couldn't raise for the first time in a petition for rehearing? Like, we did not address the jury instruction in the first opinion. And I think only in a new appeal, it was an interlocutory appeal on the grant of the motion for a new trial. So, there's new issues that could come up, and for example, the jury instruction, we didn't address that at all.
From my recollection from Sablan 1, the jury instruction as curative was addressed by this court in the opinion, wherein it stated a curative instruction was not necessary because the acts were admissible as 404B evidence. And therefore, in examining the trial court's decision for a motion for a new trial, I think that this court did actually, in fact, examine whether the curative instruction was sufficient. So I believe that the only issue that he could resurrect or could bring on appeal at this point is whether the acts counted as 404B evidence, because that is the only question that was left open by this court in Sablan 1, whether the acts constituted 404B evidence. The opinion said, but if it had constituted 404B evidence, it was admissible. And we reassert the position that this was not 404B evidence, and the government did not have to give notice of anything because it was the same act. It was the exact same act that the minor was discussing. And if you look at the testimony, what alludes to the fact that it was the same act was the prosecutor kept trying to get the minors to remember, and she could never remember the date. The only person who suggested that the act was a different date than what was charged was the defense attorney on cross-examination. He asked, what did this happen when you were 4 years old? The prosecutor's case in chief had always emphasized that she was 8 at the time, and that even in closing argument, as this court recognized in Sablan 1, the prosecutor was very clear to the jury, we are only talking about when she's 8 years old, the touching that happened in 2nd grade. So there were 2 acts that were stricken. One, when she said he touched her lap, which arguably is not a sex act because she's not specifically saying an intimate part. 2, whether he touched her private part in the 2nd grade. The unstricken testimony was that he touched me in my private. That is what we have, and that was how the conviction was returned against the defendant. So in this case, the law of the case, it was not dicta. The court went through a de novo analysis of the 404B evidence, so that is the court deciding the issue.
But was it central to our holding in Sablan 1, the 404B? You just said that we reserve judgment on it.
It was not central to the holding, and I agree that the court could have held that. It wasn't central to the holding, but I think it was necessary to analyze to emphasize why the court abused its discretion in granting a motion for new trial, so that the analysis of the 404B evidence, that was the main issue of the motion for new trial, because the central issue was material variance, and you cannot divorce an analysis of material variance with the 404B, because in order to assess for material variance, you have to take into account what acts are being alleged.
But didn't the court reserve judgment on the 404B and express doubt regarding the evidence and whether or not it constituted a 404B evidence?
In Sablan 1.
In Sablan 1.
In Sablan 1, the court reserved whether it was 404B, yes. So I do think that that issue is ripe for this appeal. And so that's why I'm emphasizing that it was not 404B evidence, because the minor was talking about the same act. And
what about the other testimony regarding sleeping at the aunt's or the mother's, where there was some testimony regarding her being on the floor and him touching her when they were on the floor? Was that the same incident?
There were 2 different incidents alluded to. I think one was on the air mattress and one was on the bed.
Yeah.
The one in the air mattress, it's unclear. That might have been a different act, but she did not, if you look at the questioning, she didn't actually complete any testimony about what really happened, if anything, on the air mattress, because the defendant had objected at that point. So the jury didn't hear anything about what had happened there. But the prosecution had never intended to bring in these other these other acts. And when you look at the investigative report, which again, that the jury did not hear, all that it says was he touched her other times between 4 to 8, and she can't remember the details and she can't remember when. So the focus was on the incident when she was 8, which was corroborated by the parents because they had said, you know, it was basically immediate outcry after he had touched her primary general area, which was the basis of the indictment.
Is there any testimony from her that wasn't stricken that supports the touching on the same time frame as the exposure?
So she said she could not remember whether it was before or after the towel incident, but the time is not an element under Campbell. And the issue with having minor victims is that they don't recall dates. So although she couldn't remember the date, it was clear by corroborative evidence of the other witnesses that all times in question were when she was 8 years old.
Yeah, but wasn't that part of the testimony that was stricken from the record?
The parents' testimony was not stricken
Right.
from the
But I'm
record.
asking her testimony, just her testimony alone.
Her testimony, she had clarified on redirect examination, which was stricken, that this happened in 2nd grade when my teacher was Mr. Kanata. And that particular statement out of everyone is definitely indicative of the same incident because all throughout the discovery, and all of these acts
Right,
were
but all
actually,
of that was stricken from the record.
it
So
was stricken from
so
the
I'm
record.
I'm just asking, focusing only on the minor's testimony now because, you know, the defense is asserting that they considered her testimony of other acts for the conviction. And I'm asking what testimony exists in the record from the minor to support the touching on the same during the same time frame that's alleged in the indictment.
So from her, we don't exactly get a date. She says he touched me in my private. However, the date range is not an element, so we do not need that testimony from her. The way that it's charged is minor under 14 years old, and she was 8 at the time. The prosecutor never alleged she was 4.
So that testimony was not stricken from the record.
Correct. She had indicated the circumstances surrounding the incident where she had placed herself in that bedroom. And because the memory of minors is not as clear as adult memories, the prosecutor needed the adults to confirm and place her in the house at the dates in question.
Maybe that's part of the problem in this case, at least in my mind, because Mr. Highsmith raises there was no notice given to the defense in terms of what other acts was intended to be introduced. The indictment made reference to a range date, April 1st through April 30th.
Right.
So if there was no notice other than what was in the indictment, then I guess Mr. Highsmith could assume that the testimonies of the victim was going to focus on this time period, even though it's not a central element. It still goes to the issue of a fair trial.
So my response to that would be the defendant had actual notice that there were other possible incidents. He had brought it up in his opening statement. So he had actual notice. There are 2 different investigative reports that where she was interviewed by the Attorney General's office, where she says that I cannot remember the dates. However, the reason why the incident when she was 8 years old came about was we were corroborating with the time she went to the police station. That was the most recent incident. Now, he says that he didn't have notice, but I think the issue here is that the prosecution didn't intend to elicit any other act. And so when we talk about 404B evidence, as long as we're bringing it in for non-propensity evidence, then it is admissible. And in this case, it was always the same act, but to the extent that she may have been talking about a different act when she refers to the air mattress. 1, there was nothing elicited by that act, and 2, that was already objected to, so that line of questioning was cut off. But 3, that's not something that the prosecutor had intended to elicit, and he made it very clear in closing arguments that he is only on trial for this 1 act when she was 8 years old. So the issue with this case is that the prosecutor asked to lead. so that we can be focused on the same incident, trial court did not allow the prosecutor to lead. So in cases like this where prosecution doesn't intend to elicit other acts, but you cannot lead a minor, and you also can't coach him or her before the trial because then you're sanitizing the actual the actual testimony. In this case, we chose not to indict any other act because there was no clear other act within the discovery. And why I emphasize that the lap incident, that was not the same as the air mattress incident. The lap incident was the same incident as the touching in my private part, because nobody had, this is not on the record, but you know, it is out of a duty of candor. I went through the discovery again, and the defendant had actual notice that before the trial started, that the lap incident was the same incident as the touching of my private part. That's how she says it. That's how she had always said it, was my lap, my private part, but she's talking about the same incident. And in this case, so given that, one, the people, if you look at the stricken testimony, again, it consists of the lap incident and the touching incident. Both of those incidents are admissible as 404B and 413. And I know that the 413 inquiry is problematic because it wasn't
Well,
brought
let's go
below.
back to the 404B.
Okay.
Why was it admissible? What was the purpose?
So
Because there wasn't anything specified by the government other than maybe character.
So that actually was discussed by the prosecutor below. I want to clarify that the prosecutor was talking about in alternatives. He said, Your Honor, this is the same act, but you know, if it's 404B, it's explaining her confusion with dates. And that is a non-propensity evidence. That's not saying, eliciting to the jury that because he committed this before, there was no time frame given by the prosecutor.
Can you explain that further for me? I'm not following why it.
So there is an exception to 404B, and I had briefed this in my brief, and then in other cases such as People v. Wesson. If a victim is talking about a prior bad act that occurred between her and the perpetrator, it comes in to explain her confusion as to why she cannot remember the date in question. So as Chief Justice was asking, what memory did she have the date? She doesn't have it. And so when she is talking about this other act, that's how the prosecution explained, that's why we cannot hone in on the date, because she actually doesn't remember, because he may have touched her one other time.
Shouldn't it proceed then to a 403 analysis? It doesn't automatically mean just because there was another purpose that could have been specified that that's the end, and that it's admissible and it's
right. Under a 403 analysis, I think that the difficulty here in this situation is that this is all happening on the fly at trial. So this is something that prosecution and defense, nobody was prepared. You know, nobody had known she was going to venture into another act, right? And so if you don't know that and you're arguing about why it's admissible, yes, the trial court should have conducted the 403 analysis. And in the end, the trial court did, by virtue of striking the testimony as inadmissible and prejudicial to the defendant. However, though, I will again re-emphasize, if you look at the actual testimony, the curative instruction was sufficient because they were instructed to only focus on essentially on the testimony where he says, or where she says, he touched me in my private, and she pointed to the area of where he touched. Anything about the lap, that's not a sexual act in and of itself. And then the touching of the second grade incident, that's why that particular incident is more problematic, because that is very clearly the same incident. And so the prosecutor couldn't ask for a 413 inquiry or for the court to conduct a searching inquiry under People v. Chanel, because in our mind, it's the same incident. So why would we ask for a 413 analysis if it's the same act and not a different act?
So you're saying with the curative jury instruction as to what only can be considered, that it was clear in the minds of the jury what evidence they could consider as a result of that jury instruction.
Right. So as this court has always emphasized, that jury instructions are so important because jurors are presumed to follow the jury instructions. So when the court told them you can only listen to this testimony, it was clear that the jury followed the instructions because they had acquitted him on the indecent exposure incident, which was on the same day. So the fact that they had acquitted him on that shows that they could listen to jury instructions and not conflate the testimony of different acts with each other, because it shows that the jury was able to distinguish any other act than the touching in the private.
But it wasn't there so much confusion. I mean, even yourself, you're saying here that that the dates were that it was ambiguous, although where the dates are not an essential element of the offense. I understand that. But once the jury has already heard this other testimony of these other acts, I understand that the jury instructions intention is that to provide guidance to the jury. But in this particular case, where there was so much confusion on the part of the minor's testimony, can it be really concluded with certainty that that was the only evidence that was considered by the jury?
And the answer is yes, because the lap incident wouldn't have led them to believe that somehow he had been continuously abusing her with any reference to the lap incident. Also, the second grade incident, as this court noted in People v. Wesson, if we charge a time frame and the act that they're referring to is within the time frame, then that is sufficient. And the defense never argued that any touching in second grade was different from the act alleged in the indictment. The defense's focus is the act when she was 4 years old, which again was elicited by himself on cross-examination. And that's why I want to emphasize that a defendant cannot cross a victim, bring up an extraneous act, and then turn around and say somehow the prosecution was the one who intended to elicit that act. Nobody ever said she was 4 years old. It was the 8-year-old incident. So as this court had noted in Sablan 1, the curative instruction wasn't necessary because it was admissible 404B evidence if it was 404B evidence. And so in this case, the curative instruction, again, the people's position was not necessary because it was the same act. And even if it was necessary, the jurors could listen to that and not conflate that with other incidents. It would be different, I think, if there was longer testimony about the different types of abuse. But again, we didn't charge any prior bad act because no one even knew what that consisted of. So we cannot actually say that the jury convicted him of other acts that were not charged because no one, including the defense, knows what even the other acts were, which is why he charged. It was an incident on the air mattress. But it was always clear that this 8-year-old was talking about the touching in her private part in the bedroom where her family places her during a limited period of time because they didn't live there. They didn't live there. They were only there for certain amounts of time. So the jury, can and did obey those instructions. And I'm just, so I want to bring back the point, though, that these arguments, the defendant fully briefed this in the first appeal. So I think that the distinction does not matter whether it was interlocutory or an appeal from a final judgment, because he had the full opportunity to brief the 404B incident because that was the basis of the people's initial appeal. And he did. And then even though the court reserved on whether it was 404B, this court still deemed it admissible. So again, a defendant cannot forego the petition for rehearing and then try to relitigate this for the second time, which is basically this is the same argument that was had in Sablan 1 as far as the admissibility of the 404B evidence.
Mr. Noy, I'd like to ask about the credibility of the witness, the child. The defendant admitted the exposure incident, but he explained it. And from what I understand, looking at the record, he also admitted that he had her underwear.
Correct.
And did she testify that he had her underwear?
Yes. Yes.
And then the parents set the time frame.
Correct.
So if the jury heard him say, I exposed myself accidentally.
Mhm.
I had her underwear. The parents say the dates. Does that lend credibility to her testimony that he touched me?
I think it lends credibility to her because it would be odd for a child to say someone stole my underwear, but if he corroborates that testimony, admits that he stole the underwear, then it lends to her credibility because then this act that's an odd kind of act, he admits that he did it. And so I think that does lend to her credibility because while she can't remember dates, she is aware of the actual acts that are occurring. And for criminal sexual conduct cases, it's sufficient evidence as long as the child testifies to the act and the circumstances surrounding the act, meaning the location, who was there, who was not there. Those are all things that she had testified to and was very clear that this happened when she was in second grade.
So we're all sort of assuming that the jury accepted the defendant's explanation that it was an accidental exposure. Is
Right.
there a conflict between her stating that and stating he touched me and the jury acquitting on that charge of indecent exposure and the touching?
No, because for indecent exposure, you have to intentionally expose yourself. And in this case, the jurors bought the argument that I guess it was an accident when his towel slipped or what have you. But the thing is, we also had to prove for the sexual act that it was an intentional touching. And so I think that those are not necessarily inconsistent verdicts. And I think that this court has previously said inconsistent verdicts can still stand nonetheless, even if this court found that it was inconsistent. But those are not inconsistent verdicts because it is plausible for a jury to say, yes, it might have been an accident when he took off the towel, but it's not an accident that he stole the underwear and then tried to touch the child. Because I think stealing a child's underwear is indicative of some type of behavior that's associated with a later intentional touching or an affinity for that child. So I do not think that those were inconsistent. And again, that shows that the jury was able to follow the elements of all the crimes if they acquitted him of the indecent exposure, given his testimony. And they were able to lend credibility to her testimony and both of theirs, in acquitting the defendant of one charge and convicting him of the other charge.
So does it simply come down to a question of whether the jury believed her when she said he touched me?
I think
Even if it was confusing on her part?
correct. So the criminal sexual conduct cases, it is sufficient for a testimony of one witness. And although the law says testimony need not be corroborated, the prosecutors always try to corroborate however you can. But given that these acts occur in secret, it is near impossible to try to hone down a time a time frame. So in this case, it always comes down to the credibility of the witness, even a minor witness. Minor witnesses are still assessed by juries the same way adult witnesses are. And, having tried these cases below many of them, it always comes down to the credibility of the witness, whether she's 4 or whether she's 50. It's still the same arguments by the defense attorneys that these kids are lying, these victims are lying, and then the prosecution has to rebut with, well, this is how we know, this is the evidence that you can consider when you're assessing whether the child is lying or not.
So my basic question is, the defendant's arguing this is manifest injustice. And what can you say to that, given the child's testimony in the circumstance?
It's not manifest injustice because manifest injustice comes when you're not on notice of these acts and you don't know that it's going to be used against you, or somehow you're prejudiced because you would have had a different defense. In this case, the defendant never said he would have had a different defense, even if that particular incident was charged or not. In this case, manifest injustice would be if the defendant was convicted of an act that wholly was not in the indictment, which is just not the case here. The prosecutor was very specific in closing argument. This happened when she was 8 years old, second grade, and around the time that the parents went to the police station. So there is no manifest injustice if you are prepared to defend against that at trial, which was in his opening argument. So manifest injustice would be if he was completely surprised out of the blue that these acts even existed. But if you look in the discovery, and I had mentioned it before, Mr. Highsmith did actually provide discovery in his excerpts of record. I do have a piece of discovery, but I didn't want to file it because it's not supposed to be filed publicly because it's discovery. However, if you go through all the interviews from the beginning, from the police report, from the two AG's office interviews, they were always on notice that this child's memory was lacking and that there may have been another incident, but it was unclear what it was. But the lap incident, second grade Mr. Kanata incident, and the touching in private part all had referred to the same event consistently across those reports. So you cannot claim manifest injustice if you can see this story and how she's referring to the same incident throughout the discovery, and then ultimately he was convicted at trial because of it.
I understand your argument that the stricken testimony didn't consist of prior acts because she was testifying to the act you say that was alleged in the indictment. But then you ask us, assume arguendo that the stricken testimony did constitute other acts and the law of the case didn't bar us from reconsidering the admissibility of that evidence. You say that it's admissible under 404B, but what about the notice provision?
So 404B, the notice is a reasonable notice before trial. I think is it's different from 413, but I think it's as long as you give reasonable notice in advance of trial. So if you look at the dates in discovery, since 2020, he was given notice in that piece of discovery that there may have been other acts, and that is the notice.
But are you required to in the notice include what the purpose of the evidence is, the general nature of the evidence that you're going to introduce, i.e. whether it's going to be to prove motive, opportunity?
I think when you give notice, if you are filing a written notice, you do put the purpose of the 404B evidence. In this case, it was different because even though we gave them actual notice, again, it was not intended to be used. But when it came up in the middle of the trial, that's when the prosecutor alleged the reason for the 404B exception.
So shouldn't the court have done the analysis that it was going to exclude or excuse pretrial notice because there was good cause in order for it to be admissible under 404?
The trial court should have conducted that analysis, but even without the analysis being conducted, the prosecutor was putting on the record how he had notice in arguing it. So even though the trial court didn't, at the time that the objections occurred, even though the trial court did not rule on 403 or rule on the notice requirement, because the prosecutor knew about the notice requirements, that's why he's saying he had notice of this in discovery, so he cannot, complain about it at this point because I was never intending
Is
to
that
elicit that.
sufficient on the 404B in terms of reasonable notice that you just provide discovery, and if there's something in there that's sufficient notice that this testimony or this evidence may come out at trial?
So I think in criminal sexual conduct cases, that is, it's difficult for that notice to be given formally. The reason why I say that is because, again, in criminal sexual conduct cases, when you have victims who have been victimized more than once, it's difficult for the prosecutor to parse out what she's going to say at trial. So it would be difficult for a prosecutor to submit a written notice to the court saying, I intend to elicit this evidence when you never intended to elicit the evidence.
Yeah, but you prepare your witness and you, based on that preparation, if there is a a chance that this testimony may deviate to these other acts, shouldn't the prosecution be a little more proactive and provide notice that this evidence may come out so that the defendant may be prepared in advance of trial?
I agree.
And whether the trial court then can decide before trial whether or not this is other prior bad acts.
I agree, but I agree that that occurs only if it comes out during preparation. So the issue is this: when prosecutors are preparing, particularly children victims for trial, we cannot coach them and we cannot say, "Hey, you cannot talk about this other act. Hey, you cannot talk about this." But we listen to what they're going to say. And in the very last interview, she never said anything about a different incident from when she was 4. That interview had occurred in 2020. At the final interview before trial, which again I can submit under seal, nobody ever talked about any other incident. She did not allude to any other incident. So at that point, the prosecutor didn't have reason to believe that she was going to say something else at trial, because in that interview, she was clear that it was just the one incident. So that's why I say it's difficult when it comes to criminal sexual conduct cases, because we'd be litigating evidence that we don't intend to elicit, or we don't even know that's going to come in. So yes, I agree that proactive prosecutors, and personally, I have done that before. I have done it just in an abundance of caution. But in this particular case, in the last interview, she didn't say anything about any other incident, and it was very clear to her we were focusing on the one incident. But when kids get on the stand and they are nervous and they're in this type of setting, and then they just think about whatever comes to their mind, it's kind of hard for us to rein that in, especially if the trial court doesn't allow you to direct the question, to use leading questions to avoid this very issue.
Any further questions? Thank you, Ms. Tenorio.
Thank you.
Mr. Highsmith, we gave her an additional 2 minutes, so you'll have your full 15 if you need it.
Thank you, Your Honor. I'm not feeling that long-winded this morning, but let's remember that a petition for rehearing is not mandatory. It is not required by the rules. And if the issues about 404B, 413, or whatever had been properly brought up by the prosecutor as they should have been, there would have been different jury instructions, and there would have been a different analysis. Now, the court, the prosecutor is arguing now that the trial court never did any analysis on 404B. That's simply not true. There are several pages of the judge's analysis in the record, and she held that I believe that report was not proper notice. The law requires that the report give the general nature of the evidence that is going to be used, but that was not done. The prosecutor
are you asserting that she has to give the purpose of why she intends to, if they intend to use that evidence, i.e. for motive, for opportunity?
I believe that's in the case law.
Yeah, but the prosecutor just argued that they had no advance information that this testimony of possible other acts was going to be testified to. So how can they give notice of something that they're not aware of?
Well, it was their report. I can look.
But I thought their argument is they didn't intend to use any of those acts that were mentioned in that prior acts that were mentioned in the report.
That is, I'm sorry, I don't mean to interrupt, but on page 156 of the excerpts of record, the prosecutor asked the young lady, "How many times did he touch you there?" And eventually he drew a distinction between her being touched when Mr. Kanata was her teacher, and shortly before she told her parents about it in the first week of May, April 2020.
But Mr. Highsmith, isn't, how many times did he touch you? Pretty open-ended. Couldn't that have simply referred to the April 15th incident?
Well, I think it obviously didn't. If you read the prosecutor's arguments, he was thinking about this all the time, right from the beginning. He didn't say anything about it in his opening statement, I believe. Which, by the way, I don't think I did either. I don't think I referred to any prior incidents. I may have said there were inconsistencies in the girl's story, something like that. I also never said the girl was lying. I said she might have argued she was mistaken or that her parents had put this idea in the record. I'm not sure which interview Ms. Tenorio is referring to when she says the final interview with the child. There's nothing about that in the record. This case was shunted around from, I believe there were 3 different prosecutors on it, one of whom was Ms. Tenorio in the early days, but she left the office. So when the prosecutor says this case was decided on the fly, or decisions were made on the fly, that's kind of true because there was no notice. There were different prosecutors. The judge was surprised as much as I was. A point about the exposure acquittal.
But before you proceed, I mean, if that is the circumstance, then what is the manifest injustice here? If there was no prior information of any other acts that may be testified to.
The notice was inadequate and it wasn't notice. It was just this report. And it says someone, according to the report, the girl said someone's hands were touching her under her clothes, that she was sleeping with her aunt. It could have been the aunt, it could have been another person, because there were multiple people sleeping in the bedrooms very frequently. It's not a very clear report.
Did you have the opportunity to use that information at cross-examination?
I didn't want to use it. I wanted to keep everything about prior incidents out. Anyway, this final interview is not in the record. I'm not sure whether it was with Tenorio or someone else. Also about the exposure acquittal, I believe that the defendant's statement to the jury may have had something to do with it, but probably the main point there was that when the girl was testifying, she was not sure whether Phil knew, the defendant that is, knew she was there, knew whether she saw anything. And that's probably the main reason for the acquittal. It doesn't necessarily lend credibility to anything else. And I also believe that when Mr. Sablan said he was in possession of her underwear, it's been a while. Please forgive me, but I don't think he admitted stealing the underwear. I think that the girl stayed at the house very often, was very close to this family, and that her underwear was in a drawer in the house. Not the same thing as stealing underwear at all. The court reserved judgment on 404B evidence in the first place. And as we know, the court must first decide whether it is 404B evidence. We think we've argued extensively and shown that it is. The prosecutors argued there were 2 incidents or more than 1 incident. She's also said there was no clear incident in discovery. And she has argued that the confusion in dates creates an exception to Rule 404B, which we disagree with. 404B has a list of exceptions that apply to 404B, motive, means, opportunity, and so forth. And these cases can be rather tricky because motive is usually pretty obvious. Opportunity, well, maybe, but really to explain the confusion in the witness's mind, I don't think so.
Well,
Once again,
what about the absence of mistake? Isn't that?
I'm sorry, Your Honor.
What about the exception or the absence of a mistake? Wouldn't that go to trying to clarify the confusion regarding dates?
We have never said that he touched her by mistake. We have never said that he touched her, but it was inadvertent. We've always argued he didn't touch her, period. And I would point out that the government has the burden on Rule 404B to show why it should come in and what exception applies. The prosecutor never offered a reason. He didn't say it was because of her confusion on dates. I don't think that's how he argued it. How do we know if the 404B evidence was 404B evident? Was it 404B evidence? They say it was not, but it's very confusing. We can't know. The prosecutor's flip-flopping on that issue shouldn't create much confidence in the jury verdict.
Assuming it was 404B evidence, the fact that there was never a 403 balancing analysis, does that affect how this is to be viewed as to whether or not the evidence was prejudicial?
Well, obviously, I think it does. Yes, Your Honor, because the 403 analysis is mandatory. Every case on 404B, I think that this case court has handed down has said that, and we don't know whether the evidence was more prejudicial than probative or not. So that alone is enough to result in a reversal because there was no 403 analysis. The jury was told nothing about 403.
What about the fact that the court struck any evidence that may go to other acts and provided a curative jury instruction that the jury was only to focus in on the testimony regarding her in the second grade?
We can't be sure they were other acts. We can't be sure which were the other acts and which were the acts for which he was being prosecuted. Even the attorney general is not sure of that. They say one time it was different, then they turn around and say, no, it was all one incident. We can't be sure what the jury what the basis of the jury's conviction was. That's really what the case boils down to. If the court has any more questions, I'll try to answer them.
Don't have it. Mr. Highsmith, in my mind, we have a real dilemma here because 413 was never analyzed.
Yes.
Because it was never analyzed, can this court consider it?
Well, I'm honored that you've chosen the hardest question for last, Your Honor, but I do not think so. I think the law requires the trial court to do the analysis and the appellate court to review the analysis for abuse of discretion, but there's nothing to review. So I think the answer is, the the case has to be reversed and remanded for that reason.
But not based on 413.
No, I don't think it can be reversed on 413. I think the court might issue some kind of statement concerning 413 that well, the parties need to be aware of this. The court needs to be aware of it, and we're sending it down so it can be done correctly. Thank you.
All right. Thank you, Mr. Highsmith. Thank you, Mr. Norio. The court will take the matter under advisement. We will issue a written opinion and now stand adjourned.
All right.